Mr. Saktiandi, Supaat.
Mr. Speaker, sir, retail and commercial leases have long been a special class of tenancies that are protected by legislation in other countries such as Australia, France and Belgium. Despite the rise of online shopping and transactions, the retail shops in our neighbourhoods and shopping malls are still an invaluable part of our lives in Singapore. This bill is significant, as mentioned by some of our honourable members who've given their speeches, as it seeks to regulate the negotiation of private leases between landlords and tenants and represents an exception to Singapore's reluctance to interfere with the free market of private commercial transactions. It goes beyond the specific and temporary interventions that this House had passed during the height of the COVID-19 crisis. One main aspect of the bill is to elevate parts of the Code of Conduct for leasing of retail premises into law. The code was co-created by the retail industry, landlord and tenant representatives through extensive discussions between June 2020 and March 2021. That time period suggests that the code was created in a context where COVID-19 had significantly affected retail businesses as footfall plunged during the pandemic. Are the principles in the code suitable for permanent adoption going forward, especially as we leave the pandemic days behind us? Clause 5 of the bill, which introduces the code into legislation, provides that the code can only be modified with the minister's approval. So I would like to ask MOS, would such a requirement introduce bureaucratic red tape that makes the code less nimble and ready to adapt to changing market conditions? And how many times has the code been amended or revised since it was initially issued? Even though Clause 5 introduces the Code of Conduct generally, it appears that the bill only gives legislative bite to Part B of the Code by requiring the landlord and the tenant of a qualifying lease to comply with the leasing principles set out in Part B. May I seek MOS's clarification, to clarify with the MOS, if the intention is for the Parts A, C and D of the Code to have the force of law as well. For example, Part A of the Code mandates landlords and tenants to adopt a consensual approach to negotiate in good faith. With the passing of this bill, is there now a legal duty to negotiate in good faith, even in the absence of an express contractual term? I understand that this is not the current state of the law. Part D of the Code also requires a landlord to provide tenant with a completed checklist indicating whether its draft lease agreement deviates or disapplies particular leasing principles under the Code. Will this become a legal requirement? While I understand that the Code has already been voluntarily adopted by major private sector landlords like CapitaLand, CDL, Frasers, and Keppel Land, I'm concerned about the compliance readiness and costs to other relatively smaller landlords of retail premises, such as, for example, MUIS or clan associations. More significantly, there has been some concern over the bill's silence on the data transparency guidelines as Part C of the Code. The tenant group, Singapore Tenants United for Fairness, or SG-TUF, made a public call for landlords to be required to provide data on the footfall and average rental per square foot in their rental premises. Such data provides tenants with a more even playing field when negotiating shopping mall leases with building landlords, especially if the lease contemplates a gross turnover rent structure. On the application of leasing principles set out at Part B of the Code, the bill provides that this would only apply to a qualifying lease. Among other things, the lease would be one which is for at least 1 year, and any period for which the lease can be later extended or renewed is disregarded. May I ask MOS, does this allow for landlords or tenants to escape compliance with the leasing principles by structuring their lease as multiple renewal period of 11 months, for example? 4 out of the 11 leasing principles under the Code relative to exclusivity terms, sales performance clauses, rental structure and security deposit can be deviated from provided that the landlord and the tenant mutually agree. However, the Code also provides that the deviations for the first 3 principles are to be on an exceptional basis. May I ask the MOS as well, does this mean that something more is required on top of the mutual agreement of the landlord and the tenant? Clause 6 of the bill also provides that any permitted deviation from the leasing principles must be declared to the Fair Tenancy Industry Committee, or FTIC, or else it might be void. The committee will maintain a register and record of permitted deviations under Clause 7 of the bill. May I ask the MOS, what is the purpose of lodging these declarations with the FTIC? Is there room for the FTIC to interfere with these permitted deviations if they have been mutually agreed by the landlord and tenant in question? I would also like to commend, Mr. Speaker, the aim of a low-cost and expedient dispute resolution process for any non-compliance with leasing principles through the introduction of mediation and adjudication processes at Part 4 of the bill. I look forward to seeing the rules, procedures, and other details that will be established under Clause 10 of the Authorised Dispute Resolution Body, which I understand will be the Singapore Mediation Centre, SMC. However, can MOS clarify if there would be a stipulation equivalent to paragraph 3 of Part D of the Code of Conduct? It says there that a landlord or tenant may escalate any non-compliance in the lease agreement to the SMC within 14 days of signing of the lease agreement. If yes, what is the consequence if the parties do not escalate the matter within 14 days of signing the lease agreement? A bit of a technicality, but I thought it's good to clear this. Are they barred from raising the issue from then on? To keep the process low cost and expedient, will the mediation and adjudication be carried out without lawyers? I also note that the prescribed mediation and adjudication process is only meant to cover a dispute over non-compliance with a leasing principle in relation to their lease agreement. If there are concurrently other disputes arising out of the lease agreement, I presume this will have to be referred to the courts or to arbitration, depending on what the lease agreement provides. May I ask the MOS, is this a circumstance where a court would exercise its discretion under Clause 13 of the bill to stay parallel court proceedings? Does this also mean that disputes over non-compliance with the leasing principles must always be subject to the mediation and adjudication process under the bill and cannot be decided by a court or arbitral tribunal? Mr. Speaker, before I conclude, I would like to briefly touch on one area which is not presently dealt with by the Code of Conduct or the bill. In most longer-term leases, including those that are renewable for further periods, there are usually terms providing for a rent review exercise to refresh the rent payable after a certain period of time. This recognizes that rent amounts are susceptible to market changes and fluctuations over time. Rent review is an area which is regulated in other jurisdictions. In France, the law provides for a legal mechanism where the rent will be revised every 3 years based on an index without recourse to the courts, following a request from the landlord or the tenant. In Belgium, a party may apply to court to obtain an adjustment of the rent where there are new circumstances affecting normal rental value of the leased building. In various Australian states, the law prescribes certain restrictions on the rent review procedure and calculation methodology that may be agreed by the parties in the lease agreement. This may be an area that the FTIC or the Ministry may wish to look into going forward. Mr. Speaker, sir, notwithstanding the clarification sought, I support the bill. Thank you.